engaged in all of those efforts at that end, but we're going to continue to encourage some discipline from your level on up into the budgetary process. Thanks.
Okay, thanks. JP, followed by Tricia Geringer.
Hi, I'm JP Cataviella with Dairy Cares. Dairy Cares is a coalition of 14 dairy organizations doing business in the state of California, representing collectively about 1,500 dairies, ranging in size from 20 cows to over 10,000. I want to thank the board for your dedication to the stakeholder process. We do appreciate that. I also want to thank the staff for their efforts to inform us and to try to extract the right information to inform you. We definitely support that effort, and we have been providing information and will continue to provide it to help steer your decisions. A couple of key things were mentioned by previous speakers. I do want to underline a couple of them. I think it's very important in the dairy program that stakeholder meetings are held outside of Sacramento. A lot of our folks, I think you're going to need to hold meetings as far south as Chino and Tulare County, and it would be nice to have one in, say, Modesto, that kind of thing. Where new fees are being considered in the North Coast, I think you need to go beyond that and actually work directly with Region 1 to hold workshops, small workshops out there to get input from the dairymen directly. And I think that if that's coordinated with Region 1, it'll be less work for your staff. So.
Good.
I have a little one concern I'd like to share about the discussion about cost drivers. So that's the game here, is what's driving the cost, what can we do about it, what are our creative solutions to that. We're asking questions, though, in the surveys, particularly if you look at pages 4 and 5 of attachment 1 for this agenda item, that really are intra-program. So they're asking the stakeholders about their program and where the cost savings can be made. And as I've mentioned to the board before, we've definitely said in comment letters, we think the big problem is one that Bill just alluded to, which is, fully half of the dairy program fees are not for the dairy program. And I'm not talking about overhead for the dairy program. I'm talking about these are other programs that are being added to the fees. It's not a problem that we're alone in, but I think if you're not asking questions about that and not sharing information about these external programs and the importance of those, we're going to end up having a discussion about programs that are already fairly lean and mean.
Right, right.
And there's no place to cut. And we need to get outside of that box and be able to have a more, substantive discussion about whether this is the best way to support these programs. We do have continuing lingering concerns about Water Code Section 13260 D1D5. This
I'm
is
not good with numbers.
mentioned.
Which one's that?
I'm going to get to, yeah.
Thank
So
you.
this is basically the language in the Water Code that says the pricing mechanism of the commodity produced must be considered
right, yeah.
when setting
Sure.
the fee.
Right.
Our concern with that has been ongoing. We've mentioned it before. Reason I'm mentioning it now is I don't see how the stakeholder process is going to address that. Bottom line is the economics, because of the pricing mechanism of dairy, the economics of the dairy industry change from year to year in good or bad ways, but the fees only go up. So we're not seeing that it's being considered, and we're not seeing that any input is being solicited on how to consider it in the future. I think we'd be remiss if we didn't do that in this process.
Yeah, I think you're right. I mean, we obviously did take it into effect by cutting it in half the year before and moving it on, which was specifically in response. So that is something we should be considering every year.
Thank you. Good point.
And I would just ask that you work with the other dairy organizations to make sure everyone's on the same page as much as possible, because I think there may be differing views on that very issue.
On whether the law should be applied?
Well, no, just as far as how complex it would be to consider different factors.
Well,
because sometimes you have good years.
I can tell you that the 14 dairy organizations that I represent, and I'm not aware of any that are not our members, are unanimous in that 13260 needs to be applied in some way. What that way is and what the best way to do it, I understand. We could come up with something that's worse the solution's worse than the problem. But right now, nothing seems to be being done other than the temporary relief that was granted last year.
Yeah, that's right.
Still
I mean, so
very
keep
appreciated.
those suggestions coming. I think that is it's a really good point you're making.
Right, and I think part of that, because this is a staff-driven process, they are asking us questions, so they're sending out lists of questions. That question ain't on the list yet, is my point, and I think I'd like to just encourage that it be brought in to the discussion.
Did you want to add something, Tom?
Well, I'll just make one comment, because this question was asked the first year that we established the dairy fees. And I'll tell you what my reply was, because at least in my opinion, that factor was considered. We set aside, we in trying to control the fees for certain industries, we set aside the fee setting process specific to 3 industries. We set a WDR fee, and then we selected out 3 industries, aquaculture, agriculture, and dairies, and set a separate fee schedule for those, ignoring the 1A through 3C approach that was being used for all the other WDRs that were issued. And in my opinion, I mean, if we had continued to just put them into the same WDR rubric as everyone else was, very large dairy, like 10,000 cows, would have to end up as a 1A classification with a fee of $100,000.
No, that's right.
Instead, we said, because we pulled them out and didn't put them into the general WDR, the result of that was that the other WDR fees rose and dairy fees dropped, and the maximum fee for a dairy now is around $10,000, I think. And it seemed to me that, and the purpose for us doing that was because those industries, in our opinion, were special. They're the only industries we pulled out of our fee schedule and identified a separate fee schedule just for that industry.
That's right. I mean, I think what may be, again, because I've corrected you when you said nothing, I do think that this gets to my point about conversations and relationship, because we know what we've done, maybe, but if it hasn't been explained or we don't talk about it over and over, people don't know. So
Sure,
the
and-
conversation should help with this
Yeah,
divide.
sure,
but-
and it's tough in a 3-minute comment slice
Right.
to go through the whole history, but of course, we've had this conversation before. I think we've had it before. I do acknowledge that first year classification separation. We've also maintained in response to that that's an ongoing duty to apply that section of the code.
Right. I'm just asking you to
and-
acknowledge when we actually have done something versus saying we haven't
Absolutely.
done anything because we're
And
trying to
maybe
figure
I
it
should
out.
have spent more time emphasizing
Right.
that. So we do acknowledge those steps that have been made. We think more can be done. Bottom line is, we feel a substantial portion of our fees are paying for programs that really aren't related to dairy regulation, and we have some concerns about that and would like to see that addressed if possible.
Yeah, it's interesting. I did some questioning on my own to some of those other agencies after the meeting where our fees seem higher. And one of the distinguishing things is that some of those other agencies have other funding sources that we don't have, whether it's gas tax money or ARB has all kinds of funds that defray costs that they can use across the board, and we don't. So there's room for thinking about finding other funding sources.
Thank you.
So, thank you. Tricia, thanks for coming.
Good afternoon, Madam Chair and members of the board. I'm Tricia Geringer, Vice President of Government Affairs for Ag Council. Our President, Emily Rooney, who I know you work with frequently, was unable to be here today, so she apologizes for that. I just wanted to reiterate and echo what has been said. The ag community certainly appreciates the efforts that the board has made with respect to increased transparency, and now hearing today a meeting schedule that's very important for our members. Ag Council ourselves, we represent over 15,000 farmers throughout the state, including dairy members, citrus growers, raisin growers, almond growers, all over the state, providing food and fiber for our communities. And I think that for us, ensuring that we get ahead of and better understand future budget deficiencies in that November, December timeframe has been really important to our organization. We've come a long way since the one meeting in May, so we do appreciate and recognize where we were a year or two ago to where we are today. But also want to reiterate that meeting late fall, early winter is very important. And then also touching base after the governor releases his budget in January. And then with respect to the schedule between January and May, understanding where are we headed, where are the new unfunded programs, what are we to expect, and what do our permit holders, what should they be expecting? So again, appreciate the engagement, especially meetings out throughout the state to engage the permit holders themselves. We think that that'll be critical, particularly for farmers, because their work days are so long. Getting out there and seeing them directly and giving them the chance in their own communities to connect is really important. And having several of those we think is important as well. So we look forward to the ongoing dialogue and continuing collaboration. Thank you.
Thank you very much. That is our last card. And let me just thank everybody for being so gracious about this start, and thank staff for being really thoughtful about it, and also acknowledging how to integrate with all the other efforts with the program staff, cost of compliance, performance review. I think if we add that plus conversations and relationship with the right constellation of players, hopefully we'll get some creative and interesting ideas that are helpful to all of us. Any other questions?
I assume you'll be putting out a schedule for what your workshops are going to, when and where they're going to be, so that we can attend if we are in the area.
We will. That was one of the suggestions that the stakeholders have too, is that the individual board members for that particular, I think Steve represents the North Coast, that if possible, could he potentially attend, and the others as well. So yeah, we will be getting out a schedule, getting that posted, getting that sent out via Lyris as a save the date type of thing.
Great, great. Thank you all very much. Appreciate it, all of it. Great. Mr. Howard, item number 8. Is he going to sing?
Are you singing? No? Well, someone's got to sing.
Well, I think Felicia likes interpretive dance. Michael's going to introduce this. We have a special guest today, and you might have noticed that we've got a cake in the back that
I did. I've been
you
nervous
should all
that
go
it's gonna
take a
become the
close look
Leaning
at
Tower
it
of
before
Pisa,
anyone cuts into it.
State agency blue.
So I'm going to keep my comments very brief, just in terms of introducing this item and our next speaker, in part because I don't want to stand between people and cake. But we're beginning our celebration of the 100th anniversary of the Water Commission Act of 1913, which, despite the date, did not become effective until December 19th, 1914. And this is, of course, the act that results in all of us water attorneys and our board members frequently bringing up the distinction between post-14 and pre-14 water rights. The act became law after it was placed on the ballot as a referendum. On that November 3rd, 1914 ballot, it was a pretty heady time for direct democracy in California, and so we had things like, should we have prohibition in California, which failed that year. But it was also the first year that we began directly electing U.S. senators, that we established legislative authority after the courts had ruled the legislature did not have authority to establish minimum wage for women and children.
Wow.
Board members may be interested in knowing that women at that time earned about $9 a week. And that's obviously pretty much comparable to what some of our regional board members are still earning. But it was also an interesting time in the water world. There was a lot going on with the legislative authority for irrigation districts, and the Water Commission Act is a reflection of a lot of those changes. I want to acknowledge...
You need to get closer to the mic, believe it or not.
I want to acknowledge not only Mike got killed. Not only are we going to kick this off with brief comments by Cliff Lee, who I'll introduce in just a moment. Most of you already know him quite well. But over on the side of the room, the Division of Water Rights has prepared a number of poster boards commemorating the event. And if you haven't noticed yet, there's a large banner hanging in the lobby. To kind of provide the context for us on the Water Commission Act, I've asked Cliff Lee, who is, in my mind, about the most distinguished and accomplished water rights attorney in California. He began his career as a staff attorney on the Governor's Commission for Water Rights Reform or to review California water rights laws back in the late 1970s. And we finally saw elements of that actually implemented this year through the Sustainable Groundwater Management Act. But since leaving that commission and staff attorney in that commission, Cliff has joined the Attorney General's office, where he's been involved in almost every one of California's significant water rights cases, the Racanelli decision, the State Water Resources Control Board cases. Amongst the state agencies, we often fight to see who gets to be the lucky agency that gets Cliff as their attorney. And so we're often having to duke it out with the Department of Water Resources and the Department of Fish and Wildlife. And that's high esteem when you have those three agencies fighting for Cliff's skills. Today, he is going to be using some of his non-litigator skills and endeavoring to educate us a little bit about the Water Commission Act. That is one of his other avocations. He is an adjunct professor at the UC Hastings School of Law. So without further ado, Cliff Lee.
Yay.
Madam Chair, thank you for the opportunity to speak today on the Water Commission Act of 1913, and also, Michael, thank you for those kind remarks. I had a conversation late yesterday with a water lawyer who will go nameless, and representing Valley interests, and I said, well, I won't be able to continue this conversation in the morning because I'm going to the Water Board celebration of the Water Commission Act of 1913. And there's this dull silence on the end of the line. He says, you really are a water geek, Cliff, aren't you? That said, I think it is worth celebrating and discussing. I'd like to talk a little bit about the pre-1913 water law in California and the problems and defects that arose out of that law. I'd like to talk how the 1913 Act came about and how it was intended to remedy that, and then perhaps briefly comment on the significance of that act as amended to this board today. All right. Well, what was the world like in water law prior to the 1913 Act? Well, as you may all recall, we had a gold rush. Miners came to California and then proceeded to extract gold and silver and other minerals from basically public domain land. In doing so, they adopted mining custom, and that mining custom was the first miner to get to a claim had a right to that claim. So there was, in essence, a placer mining custom of first in time, first in right. When it became clear that mining was going to require a lot of hydraulic effort and diversion of water, that same principle was applied to water allocation. Now, I might add, did the miners own any of that property? No. It was public domain land. Did they have any prior ownership to the mining rights? No. Did they own any of that water? No. It is not really unreasonable then to suggest that the very origins of California water right law, the first in time, first in right principle, was derived out of thievery and trespass. The California Supreme Court in 1855 affirmed that thievery and trespass and affirmed the proposition that the priority-based system of water allocation, first in time, first in right, would in fact be the law in California. And that priority was determined by not simply the point of diversion and the time of the diversion, but its actual placement to beneficial use. In 1872, the state legislature decided it should address this issue, and in the civil code, it codified this mining custom, applied it only to surface water, and then set the priority date based on the date of a posted notice of an intent to divert, usually on a tree, which was then filed with the county recorder office. So your priority date came from when you posted the notice and its recording with the county recorder's office. However, these procedures were not mandatory, and you could continue to secure an appropriative water right the old-fashioned way. Well, as you can see, this sort of self-help approach to water rights wasn't going to last as California moved from mining to agriculture to municipal uses. And in 1911, the California legislature created an entity called the California Conservation Commission, which was to look at a broad array of natural resource issues, including water resource management. The commission came out with a report in 1913, which identified a number of serious problems with this self-help water rights system. First, the commission noted that power companies and irrigation interests would post notices of intent to appropriate, fail to develop the water resources, and thus place the water in, quote, cold storage and prevent the full beneficial use of the resource. These interests would then preclude subsequent users of water through threats of litigation, which smaller diverters could not afford. Secondly, the absence of any centralized state agency loomed large. There was no agency with the authority to determine whether there was any unappropriated water at all on a stream before people engaged in these self-help measures. Nor was there a centralized state agency to make a determination about whether any of the current users were using their water illegally, outside of the priority date, outside of their season of diversion. Finally, there was no centralized agency authorized with the exclusive authority to issue water rights for unappropriated surface water, leaving water right initiation to self-help individual actions that could only be confirmed through costly litigation. The commission in its report said, quote, in language that is wonderfully colorful, which we don't see in government reports anymore, the present slipshod, haphazard methods of appropriating water have led to a condition of affairs where the last would-be appropriator must proceed to divert his water in face of a possible lawsuit, or having gotten his permit, finds that the permit is useless because all the water in the particular stream has already been appropriated, or in order to protect himself must buy off the holder of a shadowy, unperfected prior right to the use of water, which right, however, is sufficiently valid to support a lawsuit. I wish we could write reports like that today. So the effect of this in 1913 was the legislature adopted the Water Commission Act, which was actually a quite durable statute that looks remarkably similar to the present water code that this board operates under. One, there was the creation of a state water commission that authorized the appropriation of unappropriated water for surface streams. Two, the Water Commission certified water rights through a two-step process. First, you obtain a water right permit, you meet your permit terms and conditions, and then you obtain a water right license. Three, the State Water Commission is empowered to investigate, through sworn testimony if necessary, whether the use of water anywhere in the state is based upon a proper appropriation. And four, the 1913 Act declared that the unauthorized use of water is a trespass and empowered the Water Commission to initiate judicial action to enjoin that trespass. This all should have a ring of familiarity. The 1913 Act was placed on the November 3rd, 1914 ballot as a referendum and passed. Now, there's some interesting anachronisms of the 1913 Act. For example, Section 1 of the 1913 Act defines the appointed members of the 5-member Water Commission as, quote, men of practical knowledge or experience in the application and use of water for irrigation, mining, and municipal purposes. Apparently, women were not eligible to be water commissioners. Two, Section 1 of the 1913 Act further provides that the 3 appointed members of said commission, there were 3 appointed members and 2 ex officio members, the governor and the state water engineer. But the 3 appointed members shall receive as compensation for his services the sum of $5,000 per annum. Remember, this was 1913. Now, you can take out your own calculator and determine whether the present board member compensation has kept pace with the original terms of compensation legislated over a century ago. And finally, Section 8 of the 1913 Act appropriated a princely sum of $50,000 for the entire commission budget for 1913 to 1915.
We should have talked about that in the previous item.
One wonders what you could buy in 1913 with $50,000. The Water Conservation Commission also looked at groundwater. That is the commission that came up with these recommendations for the 1913 Act. And the commission said, there being no statute law in this state regarding the right to appropriate and use underground waters, such rights have been so far regulated only by court decree. Such method of regulation, the Conservation Commission believes, is not the best method. That said, the commission declined to address groundwater. It said in its report, the subject matter is, however, so vast that the Conservation Commission felt that it had neither the time nor funds necessary to make a satisfactory investigation of the subject. Now, one wonders whether the commission members anticipated that it would take another 100 years before the California legislature addressed the issue of groundwater management. But it did, and I anticipate 100 years from now, there will be another Deputy Attorney General standing in front of the successor to the State Water Resources Control Board, talking about the historical origins of the Groundwater Sustainability Management Act of 2014. And with a little luck, we might even have approved groundwater management plans. Now, while there were many similarities with the 1913 Act and the present statute under which we operate, there was one significant difference. The 1913 Act really treated the Water Board's predecessor, the Water Commission, as in essence, a ministerial accounting entity. By that, I mean the only role that the Water Commission had was to determine whether there was unappropriated water in the stream. If there was, in fact, unappropriated water in the stream, then they had to issue those water right permits under a first-in-time, first-in-right process. The California courts treated the Water Commission as a ministerial body with little discretion other than to determine whether unappropriated water was present in the water course. And this was confirmed in a 1921 Supreme Court decision, California Supreme Court decision, Tulare Water Company versus State Water Commission. However, starting in 1921, the 1913 Act was amended to require the Commission to allow the appropriation of unappropriated water, quote, under such terms and conditions as in the judgment of the Commission will best develop, conserve, and utilize in the public interest the water sought to be appropriated, end of quote. These and other amendments to the 1913 Act transformed the Water Commission from a ministerial water accounting agency to an agency with broad discretion to protect the public interest in water for the people of this state. The Supreme Court affirmed this broad conferral of public interest authority upon the Water Commission in a foundational decision, water decision in 1955, the Temescal Water Company versus Department of Public Works. I have a brief story to tell about Temescal. When I started working in water, in the mid-1970s, as a very young and fortunate staff attorney with the Governor's Commission to Review California Water Rights Law, I had an opportunity to talk to Don Stark. I'm not sure even if anyone in this room remembers Don Stark. But Don was one of those courtly, gentlemanlike water lawyers which seem to be lacking in the present practice of law. A tall and a gracious man. He was also the lawyer for Temescal Water Company in the 1955 decision. And he lost that case. Notwithstanding his very gracious and courtly nature, when I asked him about Temescal, furrowed his brow and said, "We should have never lost that case." If you looked at all the California case law, it said that the Water Board had no public interest discretion, that its activity was ministerial. All right. And then the Supreme Court came along, and they made it up. They just made it up, in his words. All right. Mind you, this was 22 years after the decision had come out. And he looked at me as a very young lawyer and said, "You know, I'm still wiping the blood off my face from that decision." And you know what? Don was right. The Temescal decision at that time was not a sure thing for the Water Commission. All prior case law had rejected the notion that the Water Board predecessor had broad discretionary public interest powers based on these untested amendments to the 1913 Act. Nonetheless, this board's predecessor chose to go long and to take the risk of asking the California Supreme Court to confirm its broad authority to protect the public interest for the people of this state. The board's predecessor prevailed in 1955, and I submit, if the board chooses to do so today, it can prevail again. Thank you very much.
Thank you very much. Thank you very much. That was great.
I'd love to have a copy of that.
Yeah.
Could you send it to us? Or send it to Michael and he can distribute it? Oh, your notes, your notes.
Well, I'll correct the typos and send it out. Okay.
If it's on the back of an envelope, you could just photocopy it for us.
No, but
That was,
at my age, everything is in 20-point type. Any other questions?
Actually, just want to give you my highest compliments as an engineer. You made me want to be a lawyer.
Thank you very much.
I'm speechless. What's next?
And at this point in time, there is cake, or you have board member reports.
Pass.
Pass.
I'll join the passage.
I'll take the cake.
Great. With that, thank you. Thank you very much. It should be fanfare and drums, but a big year. And thank you for all of that. And let's have some cake.
I just want to take a moment as we're walking in the back to thank Greg Gerhardt, who
Yeah,
in
where's
stepping into his new position, we're going to have to get him down here, took it upon himself to take the lead for this celebration. So you want to, before the cake is cut into, and there are two cakes. There is a celebratory cake, which is what you see on the stand that Greg made in the back of the room.
He made the cake?
He made the
stand?
stand.
Even more impressive.
And then there's a larger cake underneath. But on the celebratory cake, take a look at the writing around the edge, the bottom of the cake. There are words. There are a variety of words there that commemorate our water rights history and knowledge. So
Words
I just
like
wanted
riparian and
Yes.
I don't have the list in front of me.
common
A,
law.
a venerable occasion, and it is a centennial of this effort to try to restore law or maintain law and order with respect to water resources.
Yeah, and unfortunately, Greg did not get trespass and thievery on there.
And
That was
the
the highlight.
posters, where will they,
Reside.
yeah, their ultimate home posters.
the poster boards, I'll ask Kathy Moroga to come up maybe and speak to that. Kathy was responsible for pulling those together along with the banner that is in the lobby.
We're going to display these during the month of December here on the second floor foyer.
That's great.
Yeah, Janine just suggested maybe we could get all of you down at the cake before it's cut into. You can surround the
see
cake.
Greg before
It's
it's
on
cut
wheels. We will try to get Greg down
So
here
is this
too.
is the celebratory visual cake, and then there's another cake that we eat?
I'm assuming we eat both. We
This is, okay, got it. Okay, thank you. Meeting adjourned except for dessert, which is for lunch, I guess.